Is there going to be a cover-up?
Isn't that in the public interest? What could be gained by exposure?
But is the FBI in the habit of cleaning up after multiple murder?
Yes. Why do you think it's run by a man called Hoover?
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And in this episode, we will finally be breaking down the judge's ruling on denying the motion to continue. Should have had this one out to you yesterday, if not the day before, but I wanted to take extra time and care breaking down this motion because it was a very important motion in this case. As you know, I went into great depth on breaking down the motion when it was filed and the reply. And you know me, if there's any way I can produce a eye-popping bam bam in any of the information that I bring to you, I'm going to work extra hard to make sure that I do that. And boy, do I have one for you in this one. You might want to hang on to the end of this one because I'm going to expose something. And I'll be frank, after this video, after I exposed this, and it was very difficult, I mean, for years now, to be able to correlate what I had seen years ago to what I have looked at now. And once it became clear that somebody just doesn't spell very well, once it became clear, I went, whoa, here it is. So when I disclose this information that I will be disclosing close to the end of this video, I'm going to tell you right now, I'm going to put a timetable on it. And if I don't see any movement by Kohberger's defense team over the next 2 weeks after I expose this one, I mean, there needs to be a motion filed or something, then I'm going to start thinking that maybe there is some suspect things going on with the defense in this case. Because this is a straight up slap you in the face proof that could get them to the leaker well before trial, and at the very least, discredit some of that witness testimony in this case. So something better be done about it because I have uncovered it. I will disclose it. And unlike the things that I've disclosed before, gave them a direct path to the leakers, this is the final effort by POV to give them the direct path to the leakers, I assure you. So we're going to break down this motion, though. Just keep your eyes and ears open as we go through it for that eye-popping bam bam. Let's get started. Okay, so we've got the redacted memorandum decision and order on defendant's motion to continue. Now, one thing I will readily admit, if you go back to when I broke down the motion for the continue, I did state a few things as fact. One, that the defense was already typing that motion prior to the leaks at Dateline. That was obvious. And they were typing that motion prior to the leaks at Dateline based on what was said in one of the motions to preclude the death penalty due to discovery violations, clearly stating that the state was suggesting a continuance as a remedy rather than removing the death penalty. And it's not beside me to think that if I can go through that motion and I can determine what the defense's strategy was, which was clearly to remove the death penalty, well, I'm not remiss in thinking that the judge would be able to decipher that strategy as well. So when the ruling comes down on that part of it, obviously the judge picked up what the defense was putting down just like I did, and he ruled against it based on that in part. But before the court, defendant's motion to continue the trial in this matter, the basis for the motion is threefold. So there was three different arguments in here for the motion to continue, and I contend all three arguments were to remove the death penalty, and the judge picked that up and denied it based on that. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. And Taylor's been screaming that from the rooftops for months and months and months and months, but the judge, for some reason, doesn't have the ability to hear the screams. Second, he asserts that there is penalty phase investigation and preparation that still needs to be done. Without the death penalty, that wouldn't need to be done, but it absolutely still needed to be done. So that is a very sound argument for the continuance. And if Kohberger was found guilty and he was given the death penalty, you can bet that one right there is going to get the case overturned on appeal. Unfortunately, where it would get overturned on appeal, I believe, is when it gets to the U.S. Supreme Court, not the state level, so it would take years and years and years. So this is a very damaging blow. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. You don't say. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. And I would have to agree with defendant on this, mainly because of the argument that he makes about specific witnesses that will be testifying at trial. If they had time to uncover those leaks from those specific individuals, it would render their testimony less credible, if not impeach it altogether. And that's why continuing it until the leaks are found would be the right thing to do. We'll see what the judge says about that in this one. And then I'm going to give them a direct line directly to the leakers, and somebody better jump on it because it's in black and white. The state responds that defendant's motion is untimely, and he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Well, we just talked about the prejudice. So obviously this was not a good ruling by the judge, and I believe if a conviction happens and the death penalty is enforced, this one will be overturned. And the judge knows it, and I'll prove it in this motion here in just a little bit. His words contradict himself in the most important part of this thing, and he knows it. The court finds a continuance is not warranted as defendant has not made a showing there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding the trial. Yeah. Okay, standard. A motion for a continuance of trial is addressed to the sound discretion of the trial court. On discretionary matters, the court must correctly perceive the issue as one of discretion. They have to perceive it as discretion, act within the outer boundaries of its discretion, the outer boundaries, act consistently with the legal standards applicable to the specific choice available to it, and reach its decision by the exercise of reason. So, where is he getting his argument for discretion? He's siding directly with the prosecutor and the exact words of Josh Hurwit.
Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record.
Just real quick, we're all familiar with the mannerisms of Judge Hippler when somebody is speaking. And when the defense is speaking, you know, he tends to either be flipping them off or, you know, barely holding his head up. But do you notice when Hurwit here is speaking, the judge is dialed in like he's freaking E.F. Hutton or something? Judicial discretion refers to a judge's power to make decisions based on their own judgment and evaluation of a case within the boundaries of the law. This means a judge can make choices and apply legal principles in a way that is fair and just, considering the specific circumstances of the case, even when the law doesn't provide a clear automatic answer or a strict rule. And unfortunately, that seems to be the case with most of the way the law works, is it doesn't provide any clear automatic answers or strict rules, and it seems to all dictate to judges' discretion. So the judge applying legal principles in a way that is fair and just. However, when we see the argument directly out of Josh Hurwit's mouth finding its way into the judge's ruling word for word, it's like he copy and pasted his argument right at the start of the ruling. That's using, it seems to me, Hurwit's discretion, not Hippler's. All right, now this is an interesting footnote because now that we know what the ex parte filing included, which was some type of red flags in the mitigation investigation, the reason that this one is redacted, it's not just for our eyes, it's redacted for the state's eyes as well. Defendant filed some of its supporting materials ex parte, which means one party, so the state doesn't get to see it. While the court is not convinced that much of its filings is necessary or appropriate, they're not, well, if you're not convinced, then why would you rule that way, Judge? To be treated as ex parte, the court will nevertheless, in an abundance of caution, well, you haven't shown any abundance of caution on anything else, so why on this? Issue a redacted and unredacted version of this order, with the state only receiving the redacted version, given that the court is denying defendant's motion. So, that is another example of the defense not wanting the prosecution to see its confidential work product, and the judge is siding with them on this. But it's the discretionary matters, right? Discretion, just straight out. Right here in the standard, he's going to cite exactly Hurwit's words. No, he isn't biased. Analysis. Under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced absent a continuance. Unless an appellant shows that his or her substantial rights have been prejudiced by reason of a denial of his or her motion for continuance, appellate courts can only conclude that there was no abuse of discretion. Yeah, this is going to guarantee an overturn on appeal, and I'll show you why here in just a minute in the judge's own words. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. Well, the reasons that was presented to you was for mainly in this motion, the teeth was the leaks and the investigation into the leaks and your response to that. And we're going to get into it. Where a continuance is sought based on the late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to so prejudice the defense's preparation that a fair trial will be denied. Hippler admits the prosecution's disclosure violations and says they do not prejudice the defendant, right? He's sitting there saying, where a continuance is sought based on late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to prejudice the defendant's case in preparation that a fair trial will be denied. Alleged tardiness of the discovery? How is it alleged? You set discovery deadlines and the state didn't meet them. You set deadlines for their expert witnesses. The state did not meet them. The defense immediately argued that they would be prejudiced because of the late expert disclosures. And they even explained specifically in their argument that because the state issued their disclosures of their experts late, the defense was then forced to disclose theirs on time, which gave the prosecution an advantage. The defense is supposed to disclose theirs after that so that they can't manipulate their disclosures based on what the defense disclosed. That's how the law is set up. But because they didn't follow your deadlines, Hippler, and they disclosed after the defense, it gave them a tactical advantage on their defense experts. And Ann Taylor clearly had that written out in her motion. I'm not going to go back and read it. You're just going to have to trust me on this. She made that exact argument. The judge knows it. So when he says alleged tardiness, this is another example. I mean, this will be turned over on appeal. Unfortunately, I believe that appeal, if this thing gets a conviction, is not going to happen until the United States Supreme Court overturns it. And y'all know that takes decades. Defendant argues a continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigating evidence, particularly claimed newly revealed evidence that allegedly raises red flags, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media? What do you mean alleged, man? We watched it with our eyes, guy. Moving forward with this trial, he warns will violate his rights under the United States. Here it is. All right, now we got to read this really close. Moving forward with trial, he warns will violate his rights under the United States and Idaho constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent from defendant's materials, however, is any good cause for the continuance. Absent from the defendant's materials is any good cause for continuance or legitimate showing of prejudice should the trial proceed as scheduled? There's no legitimate showing of prejudice by the alleged leaks that we all watch in real time and will continue to watch. The Idaho Constitution provides additional safeguards, and they weren't listed by the defense. Then it is their fault, the judge points out in the footnote. So there is additional safeguards provided by the Idaho Constitution that aren't provided by the U.S. Constitution. The judge is doubling down on a defense error right here. That's why I said pay close attention. He's going to point it out in this footnote. Defendant specifically cites the 5th, 6th, 8th, and 14th Amendments to the U.S. Constitution and Article 1, 6, 7, 8, and 13 of the Idaho Constitution. Notably, defendant does not argue that the Idaho Constitution provides any heightened protection that the U.S. Constitution does with regard to its rights cited. Thus, the court will not engage in a separate analysis under the Idaho Constitution. So, because they didn't go into detail about the additional protection that the Idaho Constitution provides, he used it as a way to deny their argument based on the fact that they didn't point out specifically the extra protections from the Idaho Constitution. Thus, the court will not engage in a separate analysis under the Idaho Constitution. But that's okay because the judge contradicts himself here later on, and it's a guaranteed overturn in the U.S. Supreme Court. I promise you, and you'll agree with me when I get there. Oh, my goodness. Defendant has not demonstrated a continuance is warranted to review discovery. Okay, this is my big one right here, right? Because there has been, I believe now, 15 motions by the defense to get rid of the death penalty. In 3 of those motions now, even though this one wasn't a clear motion to remove the death penalty, it was a veiled motion to remove the death penalty, as I showed you, which in my opinion makes it the 3rd motion to remove the death penalty due to the disclosure. But defendant first contends that the vast amount of discovery in this case, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into his defense. 68 terabytes, we've talked about how much that is. He further argues, without any support or explanation, that there are a myriad of issues that continue to arise from the state failing to comply with discovery and expert disclosure deadlines. A continuance, he argues, is necessary for counsel to mount an effective defense. See, this is the 2nd time that he has made this statement right here. Defendant continues to complain the state's discovery violations, but to be clear, this court has found no such violations by the state. Okay, Judge, I know you've already see order on defendant's motion to strike the death penalty and adopt other necessary procedures that we broke down in detail so many times. Here's the original defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. And the attorneys of Bryan Kohberger respectfully request this court remedy the state's failure to comply with its obligations under the state, federal constitutions, state law, rules of the Supreme Court of Idaho, and the scheduling order of this court, the Judge Hippler scheduling order. The state's failed to provide expert disclosures that are specific enough to understand what testimony and discovery it intends to rely on, depriving Mr. Kohberger of the ability to conduct independent review and investigation of the evidence it will rely on. And what did she say in oral argument?
I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along, but that's not what the state chose to do. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in that the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when.
So after listening to that, and then you go back and you see He further argues without any support or explanation. He further argues without any explanation. Well, what did we just hear? The entire explanation that you set a deadline. The defense met their deadlines. The prosecution didn't. They used, just terrible tactics to gain an advantage. And their tactics that they used based on your deadline that you didn't enforce, that, by the way, even the defense said before you didn't enforce the deadline, they were scared you weren't going to enforce it, and they filed motions, and you asked them, why are you doing this? I'm going to make sure that these deadlines are enforced, and then you didn't do it. And they explained exactly what happened. They gained a tactical advantage. It's not supposed to happen in U.S. court. And then you have the gall to sit here and say he argues without any explanation? Well, I just gave you plenty of explanation. I think the defense should right now, they can take so much of this information in this judge's ruling, and I think they need to file a motion with the state Supreme Court because this is some BS right here. And I don't know how the rules apply to trying to get an order over the judge's head, and it may really make the judge mad right before trial, but you're not going to make this judge any madder to where he's going to rule any worse. And I think this is the time to take his words, use them against him, go to the Supreme Court, file a motion to try to get this thing over this judge's head because of his words right there. Let's move forward. Now listen to this. If defense counsel was truly struggling with discovery review, so he's calling him a liar, this motion should have been made when the claimed problem became apparent and certainly should have been brought prior to the expiration of discovery, all expert deadlines, and the final pretrial conference. Whoa. Let's dive into this one real quick because this one right here really makes me mad. If defense counsel was truly struggling with discovery review, if they're struggling with discovery review, this motion should have been made when the claim problem became apparent and certainly should have been brought prior to the expiration of discovery, all expert deadlines, and the final pretrial conference. Well, what did we just go over? The fact that they didn't meet the expert deadlines, they didn't meet the discovery deadlines, and they did all this right before the final pretrial conference. How do you review discovery prior to the deadlines, prior to when you get the discovery, Judge? You can't review discovery and know you have an issue prior to you receiving the discovery. So how can you say a motion to continue should have been filed prior to the expiration of discovery and expert deadlines, and you don't know you have an issue before you actually get the discovery? Now, that right there tells me Hippler in some cases could be a little bit obtuse. But instead, defense counsel has robustly litigated this case to no avail because of your rulings, retained approximately 24 experts, a full mitigation team, engaging in extensive motion practice, and disclosing witnesses and exhibit list with nary a whisper that a continuance would be sought. Nary a whisper? Whoa. These actions belie his counsel's ongoing and ultimately empty discovery complaints. We just listened to the hearing. Without more, the court can only conclude that defense counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceedings at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to defendant's substantial rights. And you know that's not what they're doing because you're going to say it here in just a minute. So that was an empty statement right there as well, Hippler. Perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and defendant ready for trial. I agree with this statement on this one right here. All right, so they've never said, okay, we need till this date to complete the discovery. That is a fair argument, and that is a fair statement by the judge. Notwithstanding all the other stuff that we've talked about, though, that is not fair. This is the first fair one I've heard in this entire motion. But then the real feelings of the judge, which is not what I read right here, comes into play. The real feelings come into play down here. The only discovery counsel claims that has not been fully reviewed are all of the thousands of tips provided to law enforcement. She argues these tips may lead to the discovery of evidence of an alternate perpetrator. Now, this is where I tell people, along with what we've already looked at, where the defense has said, first of all, let's think about this for a minute as it relates to that alternate perpetrator proffer. You see, the defense, in what I just played you in that hearing, said that they filed motions just in case the judge did not follow through with holding the state accountable to their disclosure and expert deadlines. The judge even asked them, why are you doing this? I'm going to hold them accountable. Then when he didn't hold them accountable, the defense hit him on that again. And the state did it on purpose to gain a tactical advantage. They got the defense's lists prior to them presenting their full lists, and they took what the defense's work product was with their expert witnesses and then revamped their entire case based on what the defense presented, and they revamped their case to combat that. And that's not how it's supposed to work. She said it turned the whole system of justice upside down, where the defense is supposed to receive their stuff, figure out what they're going to do, and then reply in response. Instead, the state got the tactical advantage of receiving the defense's work, and then they used it to mount their prosecution, which is unreal. So the defense, and I've said this so many times now, are not stupid. They've learned what's going to happen in this case whenever they produce their work product first before the state produces theirs. So they're not going to give any tactical advantage to the state because they know the state will do it and they know the judge will rule in the state's favor. So when you talk about the alternative perpetrators in that respect, they would never give their real story to them. And then when you look at what the judge says right here, because he's ruling on this in unison as he's ruling on the alternative perpetrator proffer, and he talks about how the defense argues tips may lead to the discovery of evidence of an alternate perpetrator. To the deadline for presenting alternate perpetrator evidence has come and gone, with no motion by the defense to extend it. Further, to offer alternative perpetrator evidence, defendant needs far more than unsubstantiated hearsay tip another person could have committed the crime, than he cites Meister. Remember, he's making this ruling in unison to the ruling he made on the alternative perpetrators. He'd already heard both of their motions, and he'd already heard already read both their motions, and he already heard their oral argument. So this tells me right here that the defense has not filed a motion to extend the deadline for alternative perpetrator because they just slapped them with some BS so that the state couldn't turn around and take their information and mount a defense against it, which is exactly why the state filed the initial motion in limine. And you go back to my video where I talked about the state's initial motion in limine on alternate perpetrators. And what did I say in that video? How did I break it down? The research that I had done based on what the state has said, I said this is a fishing expedition by the state. They're fishing to learn what the defense is planning to do at trial. And it was absolutely a fishing expedition. So the defense, instead of letting them catch the big fish, they slapped them with a little guppy on there and let the state have the little guppy to play with until trial. Bam, 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 and that's not an eye-popping bam, bam that I've got for you, but that is a bam right there, little judge. At the hearing on defendant's motion to strike the death penalty based on his counsel's alleged inability to process discovery, we just listened to that hearing that he's talking about right now and the argument on it. The court suggested several options counsel had to obtain assistance in discovery review. Now, this is where the judge is calling the defense's bluff on their tactic. And, I mean, he's right about it, but it doesn't mean he's right on the ruling. It means he's just right about he sniffed out the defense's tactic. There's no evidence that defense counsel has exercised any of these options. So when he's, without me reading this whole thing, what he's saying is he offered in that hearing the defense to get with the resource judge, get more money to hire additional staff to be able to review the discovery. And he says there's no evidence that the defense counsel did that. So that is a very good point that I agree with the judge on as far as that goes. The defense should have done that. And since they didn't, he's got something to point to. But you can only imagine that the defense didn't do that because they already have their case planned out for trial. Relevant here too, this is where he calls them on what they were trying to do, and he's right, but he's still wrong in his ruling. Relevant here too is the fact that defense counsel did not argue for a continuance as an alternate remedy to defendant's attempt to strike the death penalty because of counsel's alleged inability to get through discovery. So they didn't file an alternate for a continuance. Remember what they said in that motion. They said that they didn't want a continuance because Kohberger would have to sit in jail, and that the state was implying that the defense should file a continuance there as a remedy without saying it out loud. And the defense didn't want a remedy. They wanted the death penalty removed because of the violations, not a continuance at that point. Well, he's pointing back to what I had pointed out there. I don't know, the judge may be listening to my dang videos because he's pointing back to exactly what I pointed out there. And then he makes this bold statement, which I believe is absolutely correct. This highlights that his claims regarding the volume of discovery were used as a tactical sword, untethered to a seriously legitimate concern about the ability to be prepared. So by tactical sword, he's talking about getting the death penalty removed. Okay, remember Hippler said that it was threefold the arguments that the defense was making. We just covered the first part. The second part is the fact that the defendant has asked for more time to do a life history investigation due to the ABA guidelines, the mitigation investigation. And I'm going to absolutely agree with the defense's argument in this in the first part, and I'll agree with the judge's ruling on the second part. But you got to understand, this is just the part two of the motion. So if anything in these three arguments are legit arguments, then the judge has to grant a continuance at the very least. And when I go to just simply part two, I showed you part one where he should have granted it unconditionally. But even in part two, I'm going to agree with him on half of it and disagree on the other half, and he's going to disagree with himself and contradict himself. So if any one thing in any of these are not a sound ruling, then he should grant the continuance. But he's overruled everything in this, and he is wrong. And I think nobody can listen to what I'm presenting to you with the facts and conclude that he is not wrong in a lot of what's being ruled on in this motion. And if any one thing is not right, if any one thing is wrong, then he should have granted the continuance. But this one right here, I'm going to focus in on just this one part because we've talked hard about this. While defendant notes that the ABA guidelines for mitigation function of defense teams in death penalty cases urge counsel in death penalty cases to conduct an ongoing, exhaustive, independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense. To meet their constitutional obligations, courts look not to what is prudent or appropriate, but only to what is constitutionally compelled. So here's what the judge is actually saying right here. that the ABA guidelines for the mitigation function of a defense team in penalty cases. So the defense team has these ABA guidelines that tells them what to do in a death penalty case. And the judge is acknowledging that they tell them that they have to do all of this. However, he says the courts, see, this is the separate thing right here. The ABA guidelines tell them to do all this, but the courts look not to what is prudent or appropriate, but only to what is constitutionally compelled. So the judge is clearly making a distinction between the courts, what he's in charge of, and what the ABA guidelines tell a defense attorney that they're obligated to do to meet their constitutional obligations. And then right here, it is clearly, in his little footnote, brought to a conclusion of what should have been done. Although the state points out the Idaho Supreme Court has declined the invitation to adopt these guidelines, and he points to State versus Porter, the Idaho Public Defender statutes adopted in 2023 that y'all remember I read to you requires that the state public defender the Idaho Public Defender statutes requires that state public defenders implement ABA guidelines for defendants, attorneys delivering indigent defense services. That means a public defender. Further, the U.S. Supreme Court has recognized that ABA guidelines for defending attorneys are guides to determining what is reasonable. So the Supreme Court tells the defense attorneys that the ABA guidelines are your guide to what is reasonable. You need to do this. But the judge says, in other words, the ABA guidelines are not dogmatic code. They're simply roadmaps to aid counsel in complying with their obligations of representation. So what the judge is saying is, yeah, they need to follow these statutes as a defense attorney. However, they're just roadmaps for them in complying with their obligations, and we don't really give two craps about them. So, Judge, you're wrong. But in this aspect, though, I believe it was a really good argument. And what they did was go into, in opposition to the defendant's current motion, the state appended two tables that cross-reference the list of tasks defendant has identified from the ABA guidelines with the actual record in this case. So these topics of investigation were obtained from defendants' disclosed penalty phase expert reports. So what they did was take the disclosed expert penalty phase reports that the defense had given the prosecution, took the ABA guidelines, made a table of what Kohberger's team had actually completed, compared what they had completed with the ABA guidelines, and they had completed so much that the judge decided that that was enough. So while I do agree with the judge on this aspect, this right here is a no. But we haven't got to the big stuff yet. Now, at the close of this argument on part 2, which was the mitigation, the judge makes this statement right here. And this statement right here is why I say this is a guaranteed overturned case when it gets to the United States Supreme Court. And he should have never made this statement. In addition, while the crime victim's rights to a timely disposition under Article 1, 22 of the Idaho Constitution and IC 195, Idaho Code 195306, do not trump defendants' federal constitutional rights, they provide additional justification for proceeding with trial as scheduled. For these reasons, a continuance is not warranted. He should have never made that statement right there, because what he said, in essence, is he's using the Idaho crime victims' rights to a timely disposition under the Idaho Constitution. They may not trump the federal constitutional rights of the defendant, but they provide additional justification for the proceeding with trial as scheduled. He should have never made that statement right there, because what he said in this statement is he is using the Idaho Constitution for crime victims' rights to a timely disposition to actually trump the defendant's constitutional rights. And he knows he was wrong right there, and he knows that's going to come back and hit him because he put it in this footnote right here. Federal constitutional rights trump state constitutional and statutory rights. They trump it. U.S. Constitution, Article 6. This Constitution and the laws of the United States, which shall be made under the authority of the United States, shall be the supreme law of the land. That means you can do anything you want in the state's constitution, and it will not be anywhere near as powerful as the supreme law of the land, which is the U.S. Constitution. So to put that in there, Judge, you knew that was going to be automatically overturned by the United States Supreme Court, but you knew that it would take 10 years for this case to get there. That is unbelievably ridiculous. Now, this is where the eye-popping bam-bams are going to come in, and this is where I better see some movement by the defense on this case. This continuance is not warranted due to pretrial publicity. Defendant next seeks continuance due to a recent inflammatory pretrial publicity. On May 9th, approximately 3 months before trial is set to begin, Dateline NBC aired a 2-hour episode about this case. The episode included details and materials about the case which, if true, are not publicly available and which promote a narrative of guilt. So this was the words of the Dateline episode. Not the judge saying which, if true. That was Dateline's words. But defendant also advises that on July 9th, 2025, and I want you to remember these dates, Amazon Prime Video is planning to release a 4-part docuseries about the homicides. And on July 14th, 2025, remember those dates, crime author James Patterson is set to release a book he wrote about the same. Defendant contends that this media coverage so close to trial threatens his right to a fair trial by an impartial jury, which can only be ameliorated by continuance. In addition, defendant argues that a continuance is necessary to investigate the source of the leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. Well, by the end of this, Judge, you're going to agree that the argument, at the very least, will contain some absolutely major impacts on this freaking case, guy, because I'm going to give you a hint, and I'm not going to disclose the eye-popping bam-bam right now, but for those of you that have followed this case like I have for years now, I'm going to give you a statement right here, and I'm going to see if you know what I know or if you can figure it out before I tell you. This is all I'm going to say. Peterson, true crime guy. Let that sink in for a minute, and we're about to bust this thing wide open. But first, I'm going to give the judge this one right here. He's right. Defendant's right to a fair trial is not denied by pretrial publicity, which is likely not to subdue with time. So the pretrial publicity, while, yeah, it absolutely is hurting his right to a fair trial, it will not subdue with time. I agree with him on that. And he goes through case law about previous cases that they were able to seat a jury on, even though the jury that was able to be seated was tainted by that pretrial publicity. But in his reply, defendant argues that the allotted time is not sufficient for voir dire, given the vast media coverage. The court recognizes that more time may be needed and has built additional days for voir dire for this purpose. That's why this thing is going the 18th instead of the 11th. So he did make a remedy for that at least. And then he finishes up with, here, there is no assurance that the pretrial publicity will fade with time. And that is pretty good that there's no assurance of that. It won't. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. Yeah. It was an immediate media sensation, garnered widespread attention that not only continues to persist, but continues to grow, and it sure will grow over the next month, I assure you. 18 months ago, defendant moved for a change of venue from Latah County due in part to the extensive inflammatory pretrial publicity and allegations made by Mr. Kohberger to the public by media that will be inadmissible at trial. All that crap that the media has put forward. Motion for change of venue. He argued Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. Defendant's motion was granted, and as a result, the date was continued by approximately 10 weeks. So that did push it out. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience which is clamoring for answers. Yes, we are. The longer the public is made to sit and wait for facts to come out at trial, the more time there is for inflammatory, speculative stories, movies, books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences from future publicity. Thus, the court finds a continuance is not warranted based on the medial coverage. Rather, careful and patient voir dire is prescribed. And I agree with him on that because it's not going to get any less. It's just going to get more. Now, here comes these eye-popping bam-bams, y'all. A continuance is not warranted to investigate the leak of information. Now, this one you are wrong about, Judge, and you're going to be wrong in several ways when I get done with you. Defendant has also asserts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of leaks to the media and impose accountability. So this should answer the question for anybody out there who wonders if there is a special prosecutor investigating, because he says to accommodate the special and prosecutor's investigation into the source. So that means that's already taken place. There is a special prosecutor right now investigating the source of the leaks. But the defense also wants to impose accountability on those leakers and the people involved with those leakers. With regard to the Dateline episode, defendant points out that Dateline represented that the material came from sources close to the investigation. He notes that Patterson's upcoming book on the crime claims to be the most comprehensive narrative of the investigation and evidence to date. It's based on over 300 interviews with several individuals, including the victims' families, local law enforcement. He also notes that Amazon Prime docuseries promises to be told in captivating tense, emotionally wrenching detail by only those involved in and affected by the crime. In essence, the Amazon Prime docuseries is just part of the upcoming Patterson true crime book about the unalivings, where they will be disclosing confidential information. He argues that if any of the leaks came from witnesses the state intends to call, well, you should be able to absolutely determine by now that if the state intends to call any of the people involved in the 911 call, they've already been on TV testifying, all right? So that shouldn't be, if any of the leaks from witnesses the state intends to call, shouldn't be any question. And by the time I'm done with this, there should be no more question that the state, if they intend to call Steve G for anything, well, he should be taken care of right before then. And we'll go ahead and nail that thing here in just a second. From others involved in the investigation, information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. And I contend all they got to do is have the special prosecutor bring in Steve G, and he's going to get those leaks. So all this if, ands, and buts crap is out the window, Judge. He adds that if the investigation reveals other state agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation, and it most certainly would. As noted, a continuance is not warranted where the information sought thereby is mere speculation. And what he means by that is the information is not the information is speculation, but speculation that the person and the people involved in the leaks will be caught. Defendant Brady's argument is built on a house of speculative assumptions. An assumption that there was a leak by persons bound by the non-dissemination order, and an assumption the leakers will be found. An assumption that the leakers were law enforcement, an assumption that the leakers or others who were complicit will be testifying as government witnesses, and an assumption that these witnesses will likely be material. Well, I think the law enforcement personnel that was involved in the investigation will be material witnesses. I believe the families of the victims will be material witnesses. I believe the people that were involved in the 911 call will be material witnesses, Judge. Such assumptions are not grounds for a continuance, particularly given there is no guarantee if and when they will be confirmed or debunked. Well, they're about to be, I promise you, Judge. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leakers may never be discovered. Well, I bet you that won't happen, as I'm about to do there, Judgy. Thus, the court will not continue the trial pending the results of an investigation based on speculation that it will be successful, and hope that the impeachment evidence may be uncovered as well. Well, I'm about to tell you, I'm about to show you, Judge, and I mean it, the defense team, I better see some type of movement here in the next 2 weeks once I do this, or else I'm going to think there's something sus with our defense team if they don't. Because right here, when this says, James Patterson, the Idaho 4, an American tragedy, piggybacked on by their Amazon MGM Studios Prime Video debut of the One Night in Idaho, the college murders. While the court observed in its document and records holds order on May 15th that it appeared likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order, it could have been someone from the defense team. What? Or someone not subject to the non-dissemination order. All these people out there that tell me, oh, well, yeah, Steve G's not subject to the non-dissemination order. Go watch the pretrial conference that they had the first time Judge Hippler was involved in this case, and he clearly tells the families of the victims in this case that y'all are bound by the non-dissemination order. That is an oral ruling in court by the judge's words. The court has not made, by this statement, making a finding or otherwise accusing law enforcement or prosecution as such. Well, I'm about to. In addition, even assuming it was law enforcement who leaked the information, the FBI played a preeminent role in the investigation of this case. If the leak was or were from the FBI, the state's court's ability to further investigate it highly circumscribed and limited, if not altogether foreclosed. In addition, law enforcement in Pennsylvania and Washington may have had formal access. Yeah, no, it wasn't law enforcement in Pennsylvania and Washington, and it wasn't the freaking FBI that you don't have any power to go after. It was your local guys with Steve G. Here's the proof, along with Patterson's book. Now we're going to go back in time a couple of years. That's how old these things are, when these confidential undercover text messages that Mr. G was having with an online sleuth got exposed to the world. And I don't think it's going to be real hard for anybody to put this together, because when we look at this, number one, there's another camera here that is way better, that isn't public, that, look here, you know Mr. G had access to. He had access to a few cameras, and it's why they done the interviews. People wanted to help us. So when you wonder who exposed and leaked those camera footages of suspect vehicle to places like Dateline. Well, here it is right here. Here's him exposing it to an online sleuth. And here's him leaking it to a portion of it to an online sleuth. So there can be no more question about where the leaks come from when you just look a little bit harder. But that's not where it gets crazy, y'all. I never did understand it until I was reading the motion to continue, and I didn't put two and two together because Mr. G just doesn't type very well. But looky here, when he says, I have to keep the witness under wraps. The FBI warned me they don't play game with protected informants and they could be monitoring everything I say. We've noticed some quite odd communications and behaviors. But followed right up with that is, why did you stop working with Bloom or Blum, whatever his name is? Some other author wanted to work with us. Peterson, I think. Well, it turns out after all this time, it wasn't Peterson. It was Patterson. So there's the first admission that Mr. G has worked with Patterson. So it's no longer, conjecture or assumptions this will be found. It's found. Now, go to him, get his leak, and get it done. They told the author they wanted to go inside the house and hear things firsthand. This book will be released before the trial. Now, this is it might be over 2 years old. The Patterson book is being released weeks before the trial. Now, there's no way at this point in time that Patterson book was completed. And he knew all this time back that the book would be released right before the trial. And it's being released right before the trial. That means they held this book up to be released right before the trial strategically. And here is almost 2 years advance notice of that. And he's putting in that book and why he said he wanted to speak with us. And this is absolutely the Patterson guy, but here was where it gets the most egregious, because this is where they need to dive in and really investigate this thing. And forget investigating, they just need to go ahead and wrap it up. And the defense needs to take this and they need to go ahead and file something. The Peterson true crime guy helped connect us with a grand jury member. So whatever he got from the grand jury, people in the grand jury that he was able to garner information from and leak, that's where the leak came from. And it was from the Patterson book guy that got him connected with those grand jury members to get that information to be able to leak it. So there you go right there. There's your eye-popping bam bam. And something better be done. I better see it happen in the next 2 weeks, or I will think the defense team is sus. Which brings me to my final statements on this video. And it really relates to the last part, because now that I really think about it, some things became very apparent. And I don't know why I hadn't thought about this before. But when we go back all the way to the beginning of this thing and we go through those Steve G texts, and it tells us kind of a progression of, what he was doing, why he was thinking what he was thinking. And he expresses his feelings about not believing the roommate's testimony. He expresses his feelings about how his private investigators led them to that confidential informant, which led them to jailhouse snitches, which led them on another 2-week investigation. When I start thinking about all that, and then it pops in my head, dang, he's had the 1112 King Road camera footage since the beginning. So guess what Steve G sees that we haven't seen? He's seen the DoorDash driver's car. He's seen it from the first video. They were able to find the trail to that DoorDash driver. He's seen the sport utility that left out of there at 423. He's seen the other vehicles that obviously pulled in and out of there. He knows. He's seen Eric Grower's car come in and pull in and pick somebody up and leave. So he knows somebody left out of there, and he also sees the vehicles that pulled in after 423, because there was at least a couple of them, if not 3 of them now that I've counted. So, he knew about all this stuff this entire time, yet he only leaks what he wants to leak. He hasn't leaked anything that he didn't want to leak. So that should tell you everything you need to know right there. But in summation, just to wrap this thing in a bow, for anybody out there that thinks that the judge should not have granted a continuance after watching this video, well, then you're fooling yourself. What he should have done was preclude the death penalty. However, I firmly believe, and I think we really need to see it, because I know the defense has done this in the past where they tried to bypass the decision of John Judge and go straight to the state Supreme Court. And then John Judge ruled that they couldn't go to the state Supreme Court because of whatever reason, and he got to make the ruling on if they could go, but they at least attempted. I believe this is the time for them to take the leaks that they didn't hit real strong in their motion to continue, but they need to take and file a motion for sanctions, like I've said that they should have done a long time ago, and file it in a motion that will bypass the judge's decision and go straight to the state Supreme Court, whether that Judge Hippler knocks down their ability to do that or not, just like John Judge did. I think they at least need to make that attempt. That it needs to happen between now and trial. It needs to happen sooner than later. And I am expecting to see that. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti's out.
Oh, gonna give it a shot. Only one of me to shield you all from the enemy. You're a superhero. You're a superhero.